Good morning. I'm Ruthi Rajan, Deputy Editor of the Oath Legal Magazine. Thank you for joining the OGC Talk webinar series. This morning, our webinar is in association with the law firm Charles Russell Speechlys and legal research partner LexisNexis. On your screens, you can see the title of the topic we're covering this morning, FDI in the UAE, Part 2, New Rules for 100% Foreign Ownership. After the exciting news last year to allow 100% ownership by foreign nationals of companies licensed and registered in the UAE, it is time for us to get an update. So in this session, our speakers, William Reichert and Sarah Kadum, will take a look at the new rules and how changes are being applied and made at an emirate by emirate level. A brief about our speakers. William Reichert is partner and head of Charles Russell Speechlys Middle East corporate practice. He is a dual qualified corporate lawyer with extensive experience advising on high-value complex deals in a variety of sectors. He has more than 20 years of experience advising on matters ranging from seed series investments for startups to complex multi-billion-dollar matters across numerous jurisdictions. His experience includes advising on M&As, JVs, private equity and venture capital transactions, restructurings, and compliance matters. Sarah Kadum is an associate in the firm's Middle East offices, where she is a member of the corporate and commercial team. She acts for local and international clients in a range of industries. Sarah specializes in commercial contracts and corporate transactional work and regularly provides advice to clients on commercial agencies, distribution arrangements, franchising, M&As, corporate setups, and restructuring. William and Sarah will lead the session for the first half, and this will be followed by a Q&A session. Over to the both of you.
Thank you very much, Ruthi, and thanks for inviting us to take part in this webinar. And thanks to everyone for joining in. Obviously, a very, very interesting topic, one that has been the topic of a lot of discussion. And so we're going to try to illuminate a little bit on what has happened and particularly some of the more recent changes. So if we're going to go to the next slide, please. And the next one. Okay, so what are we going to talk about today? Well, we're going to talk about what's happened. We're going to try to summarize some of the recent changes relating to foreign direct investment. And in particular, we're going to talk about what is still subject to local ownership requirements and what is open to 100% foreign ownership. Then what we will talk about are some of the practical steps. So what LLCs need to do if you want to move to 100% foreign ownership, what might happen with the free zones, and what you might want to consider if you're in a free zone and want to transition over to onshore. Next slide, please. So what has happened? I think as we've all seen, the UAE has always been obviously a very investment friendly climate. And there have been a lot of measures taken over the last couple of years in particular to make the climate even more business friendly. So we saw a lot of new legislation last year, a lot of new legislation this year. And really, you know, whether it's golden visas or lifting of limitations on things that people can do in their personal lives, there have been a lot of changes, but you know, I think the ability to have 100% foreign ownership for onshore businesses is one of the biggest, because I think, as we all know, that's been a major stumbling block, or at least a major issue that businesses have had to deal with here. So just to recap what happened, previously the company's law restricted foreign ownership to 49% for onshore LLCs. And then last year, there was a new federal law, it was federal law number 26, that made a number of amendments to the company's law. And in particular, it amended previously Article 10 of the company's law had that foreign ownership restriction. And so now under these new amendments, you no longer have the requirement for 51% of an onshore company in the UAE to be held by a UAE national. So most of these amendments to the company's law took effect on at the beginning of this year, subject to certain exceptions, and that in particular applies to the local ownership requirement. And that came into force on June 1st of this year. I mean, in terms of what that will result in, it's not going to, at least we don't think, mean a complete or immediate move away from local sponsorship. It's not going to mean the disappearance of all the free zones, but it is going to have some big changes. Next slide, please. So let's talk about the change a little bit. So the amendments allow up to 100% foreign ownership, subject to two main conditions, and that is federal restrictions and local or emirate restrictions. So the federal restrictions, that has to do with areas of what are determined to be of strategic impact. And then the local restrictions, it's not really the restrictions, it's what's permitted. And so the local departments of economic development in each emirate will have put forth lists of what activities allow 100% foreign ownership. The areas of strategic impact, they've been set forth in a cabinet resolution, and the departments of economic development for most of the emirates, and in particular for Dubai and Abu Dhabi, which are the ones of most interest, of course, they have issued lists of permitted activities that are open to 100% foreign ownership. In addition, the amendments remove the requirement for a local agent for a branch of a foreign company, which is also a big change. Next slide, please. So looking a little bit more at what those restricted activities are. So again, there was a new cabinet resolution this year, which took effect from June 1st, and that designates the activities that have a strategic impact. And so we'll still have local ownership requirements, and that includes a number of activities where you would expect that in the sense that they are similarly protected in another number of other jurisdictions around the world, such as security and defense, military, banks and finance, insurance, currency, and then Hajj and Umrah services, Quran, and interestingly, fisheries and related services, which is somewhat surprising, but anyway. The cabinet resolution sets out the rules and conditions for each activity. And I think it's important to note, if you'll remember, there was a negative list previously, which was repealed. And there is some alignment with the negative list. For example, the negative list included defense and banking and insurance and some other activities. But there are a number of activities that were on the negative list, which are not on the strategic impact list. We'll talk about that a little more, but it's things like oil and gas, transportation, utilities, which is somewhat surprising in the sense that those are often, again, protected in many jurisdictions. And so, the UAE is really making some tremendous efforts to liberalize and open up the economy to foreign investors. Next slide, please. So we talked about the restricted list, and now let's talk about the permitted activities. So under the amendments, the company's law allows each emirate and the licensing authority, the DED, to determine both lists of permitted activities and then whether any conditions are imposed on foreign ownership of LLCs in each emirate. So in terms of the activities, both Dubai and Abu Dhabi were very quick to issue their lists and start implementing the amendments. And in fact, Abu Dhabi even issued an update to its list to further broaden it. And most of the other emirates have now also issued their lists as well. Most people are going to be, most investors are going to be focused more on Dubai and Abu Dhabi, so we're going to be talking more about those. And each one of them lists over 1,000 activities, and that ranges across a very wide spectrum of activities, again, including oil and gas. And like I said, I find that particularly interesting because that is frequently considered a sector of strategic impact, and it was previously on the negative list. So that's a very interesting development and will certainly be of tremendous interest to a lot of investors. Contracting, which is another one that's interesting because that's a heavily regulated activity. And I think everyone who's been through the process of trying to license a contracting company knows it's a pretty difficult process. And we'll see what sort of conditions are imposed by the local municipalities in terms of dealing with that without a local shareholder. Trading, transportation, again, that was one that was previously on the negative list. Hotel activities, that's going to be of interest, obviously, to a lot of foreign investors because tourism is so huge here. Agricultural activities, and again, going to our favorite subject of fishing again, there's a little bit of a disconnect because it seems as though production of fish and seafood products is permitted. So, where that disconnect is, I don't know, and we'll see if that leads to any clarification. Manufacturing activities, including activities related to defense and security. So again, there's a bit of overlap between what's in the restricted strategic activities and what's in the permitted lists, et cetera. And so, again, it really is, I think when the law first came out last year, there was some uncertainty as to how much permitted activity there would be, but there's quite a bit, much more, I think, than most people would have expected, which is good to see. Even though both Abu Dhabi and Dubai have very broad lists, they're not exactly the same, and so there are some differences. It looks at first glance, I mean, we have not gone through and compared it line by line, but it does look at first glance as though Abu Dhabi, for the time being, has a slightly broader list. And you can see here some of the activities that are allowed in Abu Dhabi, but not in Dubai. Medical facilities, interestingly, marketing and advertising activities, which is not permitted in Dubai, but is in Abu Dhabi. Various professional activities. Again, the local restrictions are determined on an emirate by emirate basis. There are certain other exclusions, and I know some questions have come in about this. For example, restaurants and education are, well, I shouldn't say they're excluded. They're not on the permitted lists, but from what we understand, some of these have been permitted on a case-by-case basis. So we'll see how that goes. Next slide, please. So talking a little bit more about the permitted activities, and there's some of what we talked about, and again the exclusions from the prohibited lists in terms of what Dubai has been doing. Next slide, please. So in terms of additional requirements, I think this was a big question mark as well. Because if those of you who were familiar with the old FDI law, if you were looking to obtain 100% ownership under what was then the positive list, there were a lot of conditions that could be attached. So strict requirements on capital investment and expenditure, use of technology and R&D. And engagement of UAE nationals. And so I think a lot of people expected, I mean, I was personally expecting this, and I'm pleasantly surprised that at least so far, we haven't seen this. But there were a lot of concerns that would be additional conditions placed on foreign shareholders that would create high barriers to entry. Again, whether that's capital investment requirements or emiratization requirements. I mean, similar to some of the barriers you see for a foreign company going into Saudi, for example. And there was concern about potential tax implications, perhaps whether the license authorities, they're allowed to license up to 100%, but perhaps maybe they would only license, say, 60%, 75%. Again, we still don't know how this is going to be implemented throughout, but so far, it doesn't seem to be the case under the amendments. The licensing authorities can come out with their own conditions. They can come out with capital requirements, different ownership thresholds, et cetera. But so far, it looks as though there will be the ability to have 100% ownership for all permitted activities. I'm sure we will see some divergence between the various emirates on this. Abu Dhabi has indicated there may be additional requirements, and that would be on a case-by-case basis. However, on a more positive note for potential foreign investors, Dubai's Department of Economic Development recently announced that there would be no new fees, no new additional capital or bank guarantees, et cetera, for 100% foreign ownership. And so, that's all very positive. And again, to me, it's a sign that the authorities here really are doing everything they can to further encourage foreign investment. So that's a little bit an overview of what's happened so far, what were the rules previously, and the changes we're starting to see. Well, I'm sure we'll see more changes, but now I'm going to hand it over to Sarah, who's going to talk a little bit about what companies might want to do if they're looking to take advantage of these changes.
Yeah, thanks, Bill. And that's a lot of information, and there have been a lot of updates to sort of digest over the past few weeks. This is a very significant change in the law, and so many companies and individuals might be left thinking, what do we actually need to do now? So I'll be focusing a little bit on the practicalities and steps that companies and investors should consider now that 100% foreign ownership is possibly an option. Now, the majority of companies in the UAE are LLCs, and so we'll focus on them in this presentation. And I would say that the first step is to start by checking whether your activity is on the list of permitted activities issued by the Department of Economic Development in the Emirate that you operate in or wish to operate in. And in terms of the DED, like Bill mentioned, that's really all that we know from them. They haven't come out with any additional requirements or conditions, but you should also check whether your activity is subject to a sector-specific regulator. For instance, this could be the Dubai Health Authority or the Supreme Council for Financial and Economic Affairs. And those types of external regulators, they will have sector-specific conditions. And you need to consider both the DED and that sector-specific regulator to have a clear picture of what your regulatory requirements are. And once you know that, you should also consider your contractual arrangement with your local shareholder. And that can be quite a sensitive but very important area to carefully consider how you want to approach. And there are many variations of what we call side agreements or protective schemes in the market. You will find trust structures or loan agreements. You also have nominee agreements. And these come with varying degrees of sophistication as well. You might just have one agreement with an individual local shareholder, or you might have a more elaborate structure where you have holding companies and SPVs, sometimes in the ADGM or DIFC. And so in all cases, you need to look at what your agreements provide. I've seen a few agreements in the market that actually envisage a change in the law that we're witnessing today. So there might be a provision that deals with this specific scenario. I've seen, for instance, call options or other mechanisms that are triggered when a change in the law happens that would allow a foreign shareholder to own more than 49%. Now, your agreement might not be that specific, but you should have a termination provision in there that you should look to understand, one, are there any conditions that apply to trying to get a local shareholder to transfer their shares? Maybe you have agreed on a compensation structure or agreed on the price of the local shareholders' shares in order to buy them out. Now, hopefully you won't actually have to resort to enforcing contractual provisions, but it is very important to know where you stand and what your position is in terms of your agreement with the local shareholder, so that you know what your rights and obligations are and what the local shareholder might be expecting. And now, if you have robust agreements in place, the path ahead should be pretty clear, and it might be very obvious what the expectations are on both sides. If not, this is the time where you have to carefully consider your strategy and put in a bit more work to devise that strategy and how you're going to go about things. And when you do consider how to approach your local shareholder, there are a few things to consider. I would say, and the reoccurring advice that we're giving is to cooperate with your local partner. Try to have an interactive approach where you sit down and have amicable conversations, because that will really simplify this process. Just because of the practicalities of transferring shares in the UAE, you will need them on board. And what your approach is will depend on your circumstances. Maybe if everyone's on the same page and you're following a exit strategy that's already predetermined or set out in your agreement, then that should be pretty straightforward. But if not, then this is where the quality of your relationship and your side agreements will be important. But in all cases, I would say proceed with a degree of caution and be conscious of the need for all shareholders to agree to the changes. It's going to be very hard for you to try to force someone out. And a few things to consider when dealing with your local shareholder is consider whether they've been an active or a silent partner. A silent partner who hasn't at all been involved in the business of the company is probably in a weaker position to try to make demands or object to your restructuring exercise. And you'll be in a better position to sort of push back against that. You should also consider whether there are any fees due to the local shareholder, whether these are outstanding annual fees that are payable under the contract, or if you've provided for some sort of compensation for them exiting the company. And another thing to consider is you might want to actually keep a local partner on board in your company. So it probably makes sense to rearrange the ownership structure so that the foreign shareholder gains a majority and assumes more control over the company. But there are a few activities where it makes sense in the UAE to still have a local shareholder on board. So you might not want to eliminate them completely, but just reduce their shareholding. And also you might need to convert your corporate form. So if at the end of this restructuring exercise, you're left with only one partner, then you need to apply for approval to become an LLC owned by a single owner. So once you're clear on how to approach things with your local shareholder, it is very important to formalize that exit strategy into a termination and release agreement. So you might be very keen to rush off to the notary public and effect the share transfer, but it is very important to set everything out in an agreement to tie up loose ends when it comes to liabilities and obligations and rights, so that you future-proof and don't have any unpleasant surprises later down the road. This is also a very good time to consider your overall structure. If you're going through with these restructuring exercises, then it's a good opportunity to make improvements to your structure as a whole. You might be aware of certain deficiencies that you might want to remedy, so you might as well do that now. You might want to think about whether a holding company structure works for you, and that is good for a number of reasons. It helps you protect your operation and assets. It could enhance business continuity and allow you to expand and restructure in the future without interrupting the business at an operational level. And so once you've figured out your regulatory requirements, you know how to approach your local shareholder, and you've thought about your overall structure, it's time to implement your strategy. So you should execute that agreement with your local shareholder, and then you just proceed with the standard share transfer process that you do before the notary public, where you sign a share transfer agreement and then you apply to the DED to amend the trade license. And if you are subject to sector-specific approvals, then you'll have to go through that process as well. Next slide, please. Okay. Now we've focused on the specifics of this change in the law, but if we look more generally, there are a few observations that we've made that we think are interesting and that are likely to have a number of implications. So one of them is, and Bill spoke about this a little bit, the difference in approach between the different emirates. So as to permitted activities and whether there will be any additional requirements and so on. And that can have both a positive and a negative impact, this divergence in approach. On the one hand, it may promote competition between the emirates. So we can look to Abu Dhabi as an example, where they were very quick to issue their list of permitted activities. And then Dubai came out with their list, which included general trading and a bunch of trading and retail activities, which weren't on the Abu Dhabi list. And so Abu Dhabi later updated their list, and it now includes general trading and a lot of other trading and retail activities. So I think that's very telling, and we might see this competition between emirates to try to become an attractive destination for foreign investors. So we might see broadening of these lists of permitted activities and just a race towards increased liberalization of the markets, which is a great thing. But on the other hand, it does add a layer of this layer of discretion between that each emirate has, could mean that there's an inconsistent application of the rules. So this could happen both within an emirate, where there's discretion to approve 100% foreign ownership for some activities, but not for others. But it could also lead to inconsistency between the emirates. And so companies, for instance, that are operating across the UAE in different emirates may face difficulties in structuring their operations if they're subject to one set of requirements in Dubai, but something completely different in Abu Dhabi. We also have something that I call gray area activities they're not areas of strategic impact, so they're not prohibited, but they're not on the DED's list of permitted activities either. So what happens to those activities? For instance, Bill mentioned this, restaurants and education. Those aren't on Dubai's list of permitted activities, but we have seen instances where the DED they've approved licensees to go beyond the 49% ownership threshold for restaurants and education. And we've received a lot of interest in this topic for obvious reasons, but there's also a lot of concerns about whether this is actually being implemented, or if it's similarly to the old FDI law, where we had a regulatory framework, but it wasn't really being applied. But what we've seen is that it is actually being applied, and companies are going through the process. I think in Dubai alone, in June, we saw over 60 companies restructure their ownership. So it is happening, and it is something that you should try to implement if you think that it would help your business. Now, we've considered what existing LLCs should do if they want to transition, but looking at new companies that are looking towards the UAE and what this law means for them, the incorporation process should be pretty much the same as to what it was before, but obviously the things that we discussed about having to look for the permitted activities list and see if your activities on that list that applies, see if you have a sector-specific regulator that has additional conditions that you need to adhere to. But other than that, the general incorporation process hasn't dramatically changed. There aren't any new regulators to deal with. And looking beyond the local ownership changes, the amendments that we refer to, so the Federal Decree 26 of 2020 didn't just amend the local ownership requirements. There were quite a few other amendments, which we'll talk about later, but some of them, if they apply to your company and require your company to make adjustments, you have to change your MOA by no later than the 2nd of January 2022. So that's important to keep in mind because there might be penalties for failure to adjust. Next slide, please. In terms of opportunities that this new law presents, we've looked at what individual companies and shareholders and investors might want to do, but on taking a step back and looking at a more macro level, the driving force behind this legislation was to increase foreign direct investment. And so the hope is that this will open the market for increased M&A activity, private equity investments, and joint ventures. And the reason is that now you can have a foreign investor purchase and own more than 49% of a UAE company. So previously, the restrictions, the local ownership requirements may have hindered or discouraged certain types of transactions, and it's quite a steep barrier to sort of get past and get comfortable with as a foreign shareholder, to have to hand over 51% of your company. But now that that's no longer there, the hope is that this will drive up corporate transactions in the country. And it may also make it easier for UAE businesses to list in foreign capital markets. So again, the previous local ownership requirements may have prevented this in many cases. Next slide, please. Now, as we said, the amendments, they didn't just change the local ownership requirements. They also changed 51 articles of the company's law in general, also very quite significant changes. And one amendment addressed corporate governance in onshore LLCs, which is the company's law previously has been pretty silent on. But we are still waiting for a resolution on corporate governance for onshore LLCs, so those details will be forthcoming. There are a few changes in the actual company's law already relating to corporate governance. So we have new rules on calling and convening a general assembly for LLCs. And they must now convene an AGM at least once a year during the first 4 months following the end of the company's fiscal year. And minority shareholders who own at least 10% can call for an AGM. There's a notification requirement of at least 21 days, and quorum is so shareholders representing 50% of the share capital at the first meeting. And if that's not met, a second meeting can be held within 15 days at which quorum is achieved by whoever's present. But your memorandum of association can require a higher quorum threshold. The memorandum must now also include a dispute resolution provision to deal with disputes and conflicts between the company and its managers and directors or between the shareholders. And LLCs or companies can now float up to 70% of their share capital, and this is up from 30% on the UAE stock market. Now, this isn't an exhaustive list of all the changes. It's only a few highlights that we've picked out. Next slide, please. So what does all of this mean for free zones? I think the general trade-off has historically been either you set up in a free zone with 100% foreign ownership, but you are subject to geographical limitations, and that's on the one hand, and then you have that versus an onshore setup, which may give more operational flexibility, but you have to get comfortable with 51% being owned by a local shareholder. And so often for foreign investors, the general advice has been to go to a free zone unless you really need to go onshore. But that dynamic has now changed, and the main deterrent for incorporating onshore has been eliminated for many activities, not for all, but for quite a significant list. And so it is likely that there will be a contraction or a consolidation of certain free zones. This is a time where free zones need to really consider their business model, their value proposition. Why are they still attractive to company owners and investors? And can they change their position to carve out their place in the market? But there are a few things to keep in mind, which we think are reasons why free zones won't be completely eliminated and aren't obsolete because of this change in the law. And that is, firstly, many activities still can't be owned by foreign shareholders in the onshore jurisdictions. And so there's still a market for free zones with respect to those activities. But even with 100% foreign ownership in onshore UAE, there are a lot of other benefits to free zones. Next slide, please. We'll look at what those are. So what is free zones value proposition now that this change in the law has happened? First of all, it's important to keep in mind that not all free zones are created equal. And I think a lot of us who've dealt with the different free zones in the UAE will know that there are some that are much easier to deal with than others. And there are a few free zones that will probably be largely unaffected, as they offer advantages that still aren't available onshore, while others will probably have to pivot and offer new incentives. But you'll see a few of the reasons why we think that free zones are still important for the market. So well established, many of them have an excellent reputation and people like to deal with them. There's also a cost element to take into consideration. Sometimes a free zone setup is a lot cheaper than an onshore setup. There are a lot of free zones that have done an excellent job in building an ecosystem and a community with sector expertise. And you might have companies and new investors wanting to be surrounded by their peers in a community and will choose to stay in their free zone. So you'll have the fashion and design companies in D3, or healthcare companies in Dubai Healthcare City, financial services in the DIFC and ADGM. You also have free zones that have built up an infrastructure around the type of activities that they license. So warehouse availability in Javza, for example. A lot of people also prefer free zones because everything is in English, and that's just much easier for some people to deal with. And when it comes to the financial free zones, specifically ADGM and DIFC, I don't think they will suffer much as a result of this change in the law, because a lot of companies and investors go there partly because of the 100% foreign ownership allowance, but also they want to deal with the regulators. They are very sophisticated and they get access to a common law court system, and that hasn't really changed. So all that to say that many free zones will be fine, but those that don't have an edge are probably not as compelling anymore. And I think we'll see a continued sort of erosion and blurring of borders between free zones and onshore jurisdictions. And that's all I had to say. Bill, do you want to wrap this up?
Thanks very much, Sarah. That was great, and obviously a lot of information to take in. So thanks for consolidating that into something digestible. Next slide, please. So just to wrap up, as we said, I mean, the change to allow 100% foreign ownership for onshore businesses, of all the changes that have happened over the last year or so, this is obviously one of the biggest changes yet. It's really going to change the landscape considerably. But it's unlikely to result in a full or immediate move away from local sponsorship. I mean, you have to remember, really anywhere you're doing business, even if there are no foreign owner restrictions, sometimes you just need someone who knows the lay of the land, who understands the business culture, who has the contacts, who can help open doors, all those things. And so, you know, it's really always important to have a local partner. And similarly, as Sarah just discussed, it's probably not going to mean the disappearance of all the free zones. As she said, some free zones may struggle more than others, but obviously some of these free zones have developed such a good reputation, such a good infrastructure, that they're pretty much economic entities unto themselves. And I'm sure they will continue to have considerable success. But what it may do is it may require certain free zones, and to a certain extent all free zones, to really be a bit more nimble and think about how they can further improve their offering. So in terms of moving forward, the practicalities are key, and you need to think about what you want to do, and obviously seek advice where appropriate. And so LLCs should consider their nominee and sponsorship arrangements, and free zone companies should consider whether they want to exit and what that will entail and what the setup requirements are. And importantly, it's important to keep monitoring the updates to the permitted activities. I'm sure that will change. With that change may come additional licensing controls and conditions. We'll have to see about that. So, whether that is capital requirements, requirement to employ UAE nationals or otherwise, that it remains to be seen. And again, as a reminder, very important for all LLCs to review their memorandum of association to make sure they comply with the new companies law, and you have to do that before the beginning of next year. So that's really a summary of the changes to date. I know there were a lot of questions that came in, and I'm sure we won't be able to answer all of them. But I know that Ruthie, I believe you've picked some out that should cover most of the questions that have come in. So hopefully, if we don't answer every question, we'll at least touch upon the main themes that have been asked. So Ruthie, I'll hand it back to you.
Thank you, William and Sarah, for sharing your insight with us this morning. Extremely helpful. As you mentioned, we do have a few questions that have come our way. So the first question is the local ownership requirement for the areas of strategic impact still 51%?
So on that one, the recent cabinet resolution on sectors of strategic impact, it defers to each regulator how that is determined. The resolution specifies who the regulator is and allows that regulator to determine the percentage of local versus foreign ownership, as well as whether there are any conditions or controls that will apply. Again, going back to my favorite subject, fisheries, that's the only one where the resolution did provide that it must be 100% local ownership.
Thanks, William. The next question is a bit of a long one. Are there any differences between the various emirates as to the permitted activities, percentages of permitted foreign ownership, capital requirements for increased foreign ownership, etc.? And what are the implications of a difference in approach?
Right. And the short answer is yes. The licensing authorities, so the DEDs in each emirate, they will issue their own lists of permitted activities that apply to companies that operate within that emirate. And the DEDs, the local authorities, have been given quite a lot of discretion to determine the conditions that apply. So as Bill mentioned, we haven't seen anything come out yet in terms of additional requirements, but that is left to the discretion of each DED in each emirate. And so we'll have to see what they come out with, if anything. Dubai has said that they won't have any additional controls. Abu Dhabi, I think they're taking on a slightly different approach and saying that it'll be determined on a case-by-case basis. But yeah, it's an interesting and a good question, and we'll have to see how this will affect companies that apply, that work across various emirates, and how they have to structure their operations.
Sarah. The next one, are there any share capital requirements for foreign-owned companies or other soft requirements?
There are some general requirements under the law, under the company's law. For example, that a company must have share capital that is sufficient to sustain the business. So, I mean, those kinds of requirements are still in place. But again, going back to what we said earlier, the Departments of Economic Development, at least so far, they have not come out with any heightened share capital requirements for companies that are more than 51% or more than 49% or fully owned by foreign shareholders. Abu Dhabi has suggested that they may assess this on a case-by-case basis, but they haven't come out with anything concrete. And to the contrary, Dubai has come out and affirmatively said that there would be no additional requirements. So, so far, no, there aren't any additional capital requirements, and there may be some on a sector by sector specific basis. Again, we mentioned contracting earlier, where there are usually additional capital requirements, but again, nothing specific under the law, and same, you mentioned soft requirements, and we haven't seen anything on that either.
An interesting one next. What if you have companies in Dubai and Abu Dhabi and your activity is on the Dubai list but not on the Abu Dhabi list, or vice versa?
Yeah, that's an interesting one, and it's quite frankly a question that I want a clear answer to as well. We've had some talks about this and tried to figure out how this will be dealt with, and honestly there isn't a clear answer. I can speak to what generally happens, and that is that a company is always subject to the local rules imposed by the licensing authority in the emirate that it operates in. So if you have a company that can own 100%, a foreign shareholder that can fully own its company in Dubai, but not in Abu Dhabi, I think that's one of these areas that we need clarity on from the DED in the respective emirates, so that we know how to go about that. And I think for now, the only sort of advice that or guidelines that we can give is that you probably have to have different ownership structures in each emirate. So where you can own 100% in Dubai, you can have one type of ownership structure, but if that activity that you're undertaking isn't on the permitted list in Abu Dhabi or vice versa, then as it looks now, you probably have to have a different ownership structure in Abu Dhabi. And then that also we'll need to consider, for instance, what if you have a branch of a Dubai company in Abu Dhabi? So all that I probably didn't give much comfort in that answer, but it's still early days and we don't actually know how they will deal with these types of questions. So those are a few areas that we are expecting the DEDs to provide clarity on and to further streamline the process so that foreign investors can know what they need to be doing.
Thanks, Sarah. And I know there was a bit covered on the free zones. The next question is, if we are a free zone LLC, should we now move to onshore Dubai?
I mean, it's funny because after the new law was announced last year, we got questions almost every day on that. I mean, whether it was foreign companies that had a free zone company and said, great, now should we move onshore? Or investors who were looking at the region or looking to do a joint venture and saying, well, now can we do our 100% owned company? And that was before the permitted activities came out and said, well, let's just slow down a bit and wait and see how it goes. And again, I did not think that the ownership permissions would be as broad and liberal as they are. And so, there's tremendous opportunity to do so if a foreign investor would like to do so. But it's not such an easy question. And for those who have worked both onshore and in the free zones, there are a lot of other differences other than just the foreign ownership requirements. And so, you really need to look at it on a case-by-case basis. And you have to look at your operations and determine whether there are other reasons other than just foreign ownership that makes it worthwhile staying in the free zone. First of all, from an administrative and corporate governance perspective, it's often a lot easier working in the free zones. Whether it's a question of just doing everything in English as opposed to Arabic, a question of ease of transferring shares and not having to deal with a notary all the time. That's a significant issue. There are cost questions, and sometimes the free zones, quite frankly, depending on the free zone, they can be expensive, and that might be a reason to go onshore. But there's also a cost in making that change. And so if you're in a free zone and your cost burden is relatively low, that would not in and of itself be a reason to change. And so you'd have to consider the costs that would be incurred in moving onshore. I think then, touching upon what Sarah was talking about in terms of the advantages of the free zones, a lot of these free zones have done just an amazing job in creating a very unique ecosystem. And so some of these free zones, you will have some really specialized sector expertise. There's a community, and so you're surrounded by your peers. It's kind of like, why do all the big tech companies in the world go to Silicon Valley? Because all the big tech companies in the world are in Silicon Valley, and so you've got that ecosystem, you've got the talent there, and it's easy to share ideas and all sorts of things. So whether those are fashion and design companies in the Dubai Design District, or healthcare companies in Dubai Healthcare City, or the financial free zones, DIFC, ADGM, that ecosystem is not something that's easy to replicate necessarily. There can also be questions about infrastructure. For example, in JAVSA, they've done a fabulous job with the warehousing infrastructure, and so you may not be able to find that kind of support onshore. So it's in summary, it's not an easy question to answer. I don't think that all of a sudden, as we were saying, that everyone is just going to dump the free zones and go onshore. I think the free zones are definitely here to stay. And quite frankly, you look at plenty of other jurisdictions around the world where there are no foreign ownership requirements, and there are still free zones there as well, and they are often very successful.
Thanks, William. More of a general question. Will there be any further legislative changes in this area?
I think so, yes. There are still a lot of areas that we're not entirely clear about, that we are expecting certainty on. And as I said, it's still quite early on in the process. These laws are quite new in terms of enforcement and application. And so, well, firstly, we expect the DEDs to continue to modify their approaches, and they might revise their permitted activity list, just as Abu Dhabi has. But they might also come out with the additional requirements that we've mentioned. And so we're waiting to see, also from an application perspective, how they actually, what the process is and how they apply these new rules, but also if they're going to come out with regulations and guidances to solidify their approach and the rules and conditions that apply to specific activities. I think another area that we're not entirely clear on, that I hope we will get clarity on, is whether there will be instances where more than 49% ownership is permitted, but not the full 100%, and in what areas that will be the case. There's also still few things to be resolved in terms of the areas of strategic impact. So if you look at the resolution that was issued, it sets out what these areas of strategic impact are, who the regulator is for each activity. And then it says that the rules and conditions that will apply will be determined. And so that's something that we're also still waiting for. So it is an area that of the law that will probably be subject to quite a few updates and modifications. So it's something that we have to continue to monitor. But it seems like it's going in the right direction.
And I think I'd actually also add to that, you know, as Sarah noted before in our presentation, you know, this is probably going to lead to a certain bit of competition between the various Emirates, and that's a good thing. You know, as we saw, Abu Dhabi came out with a list, and then they amended their list. Was that because Dubai came out with their list and they want to get ahead of them? It's not clear. You know, who knows? But I wouldn't be surprised, particularly with some of the smaller Northern Emirates, that they may try to open up and attract foreign investors with permitted activities they're not in Dubai and Abu Dhabi, where everyone is going to go to in the first instance. And again, that's a good thing. I think the more competition among the various Emirates, the better it will be for investment generally.
Thanks, William, and Sarah as well. And I know that we are approaching time, but there is a couple more questions that we'll take up. Is there any discretion by the authorities to deny 100% foreign ownership if the company activities fall within the activities?
Yeah, so again, going back to how the law works, you know, again, there's the strategic, the sectors of strategic impact, and there, you know, that's federally mandated, and that is where you can't have full foreign ownership. But for the permitted activities, that is all determined locally by each emirate, and so the licensing authorities, the Department of Economic Development in each emirate, they will have the discretion, so you know, they can impose the conditions, and you know, the general expectation is that if, you know, your activity is on the list, probably you can own 100%, but we can't be sure. There may be further restrictions. It goes to the previous question about, is there going to be more legislation? You know, it's going to be clarifying these issues. And similarly, you know, as we noted, there are instances where you know, certain activities are not on the permitted list, but we've seen on a case-by-case basis that they may allow for more than 49% foreign ownership. So yes, there definitely is discretion on an emirate by emirate level, you know, provided that it doesn't fall within the federally mandated activities of strategic impact. There is no or there's less local discretion.
And how do existing LLC companies transition?
Well, just to recap the action plan that we sort of laid out and discussed before, I would say the first thing is check if your activity is on the list of permitted activities in the emirate that you want to operate in. You also have to check if you are subject to a sector-specific regulator. Talk to your local shareholder and see what your exit strategy or what their exit strategy is, and agree on that and finalize an agreement with them. And then in terms of the procedural steps, it's pretty much the same as a standard share transfer in the UAE. So you apply for initial approval with the DED. If there's a new incoming shareholder, that incoming shareholder has to be vetted. If there's not a new incoming shareholder and you're left with only one shareholder in the LLC, you would have to get approval for the LLC to become an LLC owned by a single owner. Then you go to the notary, you sign the share transfer form, and you amend the MOA to reflect the change, and then you ask for the DED to amend your trade license to affect that share transfer. If you are also subject to one of these sector-specific regulators, then you'll have to check with them and see what their conditions are, and that's it remains to be seen how those conditions and the approach taken by certain sector-specific regulators that might actually create a hindrance to a company transitioning into full foreign ownership, because they might have a requirement that you have a local shareholder on board. But that's probably assessed more on a case-by-case basis. But generally, the process of transitioning it's not all that different to what a share transfer looks like and has looked like before this law came into effect.
Thanks, Sarah. I know we've been receiving quite a few questions, but we'll just take 2 more before we end the session. We've received many questions on whether a specific activity is open to 100% ownership.
Yeah, and generally speaking, that's pretty easy to confirm. You can just look at the websites of the Department of Economic Development for each emirate, and it will show those activities. But again, going back to what you just said a few minutes ago, even if the activity is not on the permitted list, so long as it's not considered of strategic impact, it's still possible that it might be permitted. Just because it's not expressly permitted doesn't mean that there might not be exceptions. And so you can inquire with the DED, and I think also a lot of these activities, it may not be clear for a particular company, what category it falls under. And so again, it's a question of inquiring with the DED, having that discussion and seeing whether it is open. But for the most part, if you want to find out what the activities are, just go on to the website for the DED of that emirate, and it should be right there.
Thanks, William. We'll just take the last question. Can an existing Emirati sponsor raise legal barriers or seek financial compensation for being removed from a Dubai LLC?
Yes, probably not what you want to hear, but that's why we reiterated the importance of working with your local shareholder. And they can make it quite difficult to transition to full ownership if they want to. And again, this is where the quality of your relationship with your local shareholder comes into play, and the agreements that you have between you. But if you think about the practicalities of transferring shares in the UAE, usually all shareholders or their authorized representatives have to appear before the notary public to sign the share transfer form. And so if you have a local shareholder who's just digging their feet in and their heels in, and they don't want to cooperate, you're gonna have a difficult time and might have to go down a complicated legal route. And so trying to deal with your local shareholder in an amicable manner is the preferred approach. And to I think the question also asked whether financial compensation for would be applicable, and that depends on, firstly, on your agreement. If it provides for that, then that's something that the local shareholder is probably going to try to enforce. But even if there isn't a financial compensation provision in your agreement with the local shareholder, it might be something that you end up agreeing to nonetheless, just because if that's something they demand, it might, and it's relatively reasonable, it'll be a commercial decision at the end of the day, but it might be worth it rather than trying to go down a legal avenue. And so you would have to weigh the costs and see where you end up. But I would say try to go about this in a cooperative manner.
Thank you, William and Sarah. I know that we've approached the end of our session. Thank you so much for your practical insight on this crucial topic. I believe we've covered some of the main questions that have come in. And if the delegates have any further questions, please do reach out to the speakers, or you can forward it to us as well. Our sincere thanks to the firm Charles Russell Speechlys for leading the discussion. Emma at the firm, thank you for your help, as always, for organizing the session. We would also like to thank our legal research partner, LexisNexis, for their support. And also to my colleagues at Niche Publishers, and especially to Sandhya Devakaran, co-organizer of this session, for your support this morning. Recording of this webinar will be available on the Oath Magazine's website. Thank you all for joining us this morning. Thanks again, Sarah and William. I wish you all good health and have a wonderful week. God bless. Thank you.
Thank you.
Thanks.